Organisers of this wonderful event, organising institutions and your representatives, presenters, ladies and gentlemen, it is an honour to be joining you from Australia tonight, midday for you and morning on the other side of the world. I really want to congratulate you on the forum that you've established, bringing together so many different voices from the Global South and those with an interest in the Global South and financial crime. I'm really looking forward to a fantastic program that you've put together, touching on key themes. Yes, FATF and the FATF standards are at the heart of the discussion, but I also look forward to the discussions around implementation challenges. We've been dealing with those challenges now for over 3 decades, and we are discovering new challenges as the standards evolve. And we certainly have not solved the problems relating to the old challenges in the vast majority of countries in the Global South. We're grappling with unintended consequences, and it's great to see that you will be addressing non-profit organizations and civil societies that are particularly hard hit by Recommendation 8, and that is not yet well served by the revisions that have been introduced to alleviate their plight. Financial inclusion and technology is an area where I've spent a particular amount of time, and I'm gratified by the level of attention that it is enjoying, especially as we are working towards the United Nations Sustainable Development Goals and the target date of 2030. And in the same way, de-risking and debanking that is still bedeviling access and undermining financial inclusion, not only for the poor, but also for innovative fintech companies that attempt to serve the interests of those of those groups that are classified as lower income. And then, of course, black and grey listing. And it's great to see a number of papers focusing on that. The debate is still continuing as to whether the impact of listing has actually been as economically devastating as believed by some countries. And I'm looking forward to interesting discussions in that regard. And that brings us to the concluding discussions that I find really constructive, focused on solutions. Now, in this program, I thought I'll introduce another element that interests me and that I do think should enjoy more attention. We focus on the standards, we focus on the implementation, but a key part of that implementation lies in the mutual evaluation process, and actually the assessment process that's conducted by other countries of every country's legal system and implementation. Now, I'm going to highlight my concerns using just 3 examples drawn from the recent South African mutual evaluation report. Now, bear in mind, we are speaking about assessments that are being done in terms of a mutual evaluation methodology that's quite detailed. The assessors are handpicked. They are experts and they are given training, but then they are sent into a country with a different legal system at a different context. And under time pressure, and based on documents provided by the country, they need to grapple with and come to grips with the system of that country in order to determine whether that country complies with all of the different standards, both technical and, of course, with the effectiveness outcomes. So with that in mind, the South African mutual evaluation. And as an educator, I apologize for the very busy slides. I tried my level best to simplify them, but because we're speaking about reports that are text heavy, 200, 300 pages. It's difficult to lift out some of the problems without being slightly text heavy too. So the first example I want to deal with addresses terror financing concerns, and especially the fact that South Africa's terror financing penalty is viewed as too low. The terror financing offense of South Africa, and you find the quote there in orange, is 15 years imprisonment. And the report stated, when compared to a maximum penalty of 30 years for money laundering, it is not possible to conclude that the sanction for terror financing is proportionate. Now, that in itself is a fascinating statement, open to a lot of textual analysis. But in essence, yes, FATF's methodology requires assessors to consider whether penalties for terror financing and money laundering are effective, proportionate, and dissuasive. So it's quite correct that this features in the report. But what is interesting is the critique in relation to the 15 years and the basis for that critique. Because a study was done 7 years ago, looking at the maximum penalties for terror financing for more than 170 countries. And according to that, South Africa falls with 15 years right slap bang in the middle of countries where penalties range from less than 10 years in 53 countries to more than 21 years and or capital punishment in 60 countries. And South Africa results nicely in the middle of that. So what's been used as a yardstick to come to this conclusion and criticize and downgrade South Africa for a terror financing sanction that is not sufficiently proportionate? It seems what is used as the yardstick is the penalty for money laundering. Now, the penalty for money laundering in South Africa was astonishing when Parliament initially adopted it. And it was said at that stage that it was actually a mistake that was made in a late night session, because 30 years is very harsh compared to international standards. To use that as a yardstick, rather than to question whether such a high penalty is actually proportionate, is problematic. And in addition, what the report does not touch on is the fact that the South African framework, AML CFT framework, actually contains a RICO type offense. And for those who commit more than one terror financing offense, they may actually be charged under that offense, and there the penalty is life imprisonment. The criticism is in the report. The result is that the South African government is currently working on a bill. Work started even before the official report, the version was published, because they knew what was coming, to adjust the terror financing penalty to 30 years. Right, a second example. This relates to criticism about prosecutorial discretion around identifying terrorism. And essentially, in that orange text, the concern expressed is that there's a reluctance to characterize acts that involves political violence and that may suggest extremist motivations as terrorism. And because there's a reluctance to classify such acts as terror financing, it means terror financing offenses can't be investigated and prosecuted because there's no offense for financing simple acts of violence. In essence, the criticism was summarized in paragraph 227 as South African authorities would not presume a terrorist act had occurred upon identifying evidence of domestic political violence or extremism. Now, if we reflect on that as lawyers, prosecutorial decisions have to be made in a broader context of a country, and they need to reflect a range of public policy concerns. South Africa is still a young democracy. Political violence still occurs. But is every event of political violence even extreme, where they may involve elements of extremist thinking? Should that be likely classified as terrorism in a country with a young democracy? And if assessors do not consider this, what are they packaging in the reports that criticize a country and compels its policymakers to amend their laws or amend their practices, or in future more likely classify such acts as terrorism in order to meet what assessors view as FATF requirements? And lastly, just a third example, self-laundering. From the start, South Africa's framework included a self-laundering offence. In its 2009 mutual evaluation report, it was criticised for not meeting the technical requirements of a self-laundering offence. The government did not agree, but they pushed back on constitutional grounds, saying expanding it would lead to a duplication of charges. And that would be contrary to South Africa's constitution. What is interesting is the reasoning of the assessors in reply. They said, as for the constitutional argument, we note the High Court judgment that the government provided on the interpretation of the South African Constitution, but that decision of the South African High Court would not be sufficient confirmation of a constitutional principle absent the pronouncement by the Constitutional Court of South Africa. Now, the Constitutional Court of South Africa is the apex court, and it is the apex court in constitutional matters. But the High Court has constitutional competency on constitutional matters too. It is just not the apex court. For an assessor to take a position that I will not listen to a finding of a High Court unless the government has taken that through the processes to get a final decision of the apex court in constitutional matters is, I submit, extraordinary. In the 2021 report, they returned to this argument and actually downgraded South Africa on it, saying South Africa in terms of recommendation 3 is largely compliant except for this minor shortfall regarding self-laundering. And then there's a theoretical argument that I don't want to drag you through that's highly technical and frankly, as a South African legal expert, I do not find convincing. But interestingly enough, in a later part of the report, they point out that for the 5 years before 2019, 63% of all convictions obtained for money laundering in South Africa was obtained on the basis of self-laundering. Now, ladies and gentlemen, South Africa is not the only country where this has happened. It is just a system that I'm intimately familiar with, and therefore I read the report with different glasses. But we're now looking at a few other reports of other countries, and we're finding other such examples of positions taken by assessors and views expressed that are difficult to reconcile with the actual legal position. So why do we see these findings? And I do not have answers. I put them forward for discussion. Is this reflective of a lack of comparative legal expertise and sensitivity of the assessors? And comparative legal studies is complex. Are we seeing large teams of assessors for all jurisdictions around the world having that capacity? But countries may push back. Why do these findings end up in the report? Is it a lack of capacity of the country, or is there a lack of a will to push back on certain of these issues? Is there a lack of appropriate quality control within the FATF? one proposal that I would have to improve processes is actually to publish drafts of mutual evaluation reports to enable lawyers and AML experts of the country to review that report and to provide comments to ensure that unnecessary mistakes are not made. Now, these are technical matters. I've given you a link to a book where these 3 examples are discussed in greater detail, but there's much more to this discussion. So in conclusion, ladies and gentlemen, I'm strictly trying to keep to my time. What I wish for this conference to bear in mind and discuss as the papers are presented are the following 2 questions. We know huge mistakes were made in the past, but is the Global South now using its voice in and into FATF effectively to prevent unintended consequences? And what can we as researchers do to strengthen the contributions of the Global South to FATF debates? Because they are part of the debate, but is their voice worded in such a manner, and are they able to provide the evidence to actually swing the debate in their favor when that is required? Now, ladies and gentlemen, with that, I wish to conclude again with a congratulations to the organizers, to the organizing institutions, and of course to you as participants and the presenters of the papers that we're going to listen to during the next few days. We look forward to a fascinating conference. Thank you so much.